A driving while intoxicated or DWI arrest is one of the most common ways ordinary citizens interact with the criminal justice system. A conviction can have significant consequences. The first thing our DWI clients usually ask is, how can I beat this charge? Burden of proof. A DWI charge in New York is a criminal offense. In criminal cases, it's the state's responsibility to prove the accused person's guilt beyond a reasonable doubt. Beyond a reasonable doubt means the judge or jury have to be virtually certain that the accused person is guilty in order to convict them. It's the defense's job to poke enough holes in the state's case to make the judge or jury doubt that the person committed the offense. Examples of DWI defenses. One common way to defend against a DWI is to suggest that there is an issue with the breathalyzer. Breathalyzers have 0.01% error margin. This makes all the difference when someone's blood alcohol content, or BAC, was just within the range of what's illegal. For example, one of New York's DWI offenses makes it illegal to drive with a BAC of 0.08% or higher. If an accused driver registers a 0.08% BAC, and a breathalyzer can be off by 0.01%, who's to say their BAC wasn't actually 0.07%, which is within the legal limit for that offense? Another common defense is to question the field sobriety test. One problem with field sobriety tests is that they are very subjective. Officers often interpret them incorrectly or unfairly. The good news is that usually the officer's evidence, submitted in the form of a roadside sobriety report, can be challenged. We can often convince a judge or jury to question the field sobriety test by effectively cross-examining the officer in court. A good example of this is the case of People v. Brown. In this case, Brown failed his field sobriety test when he was pulled over for erratic driving. The officer admitted in court that there was no smell of alcohol in Brown's car and that Brown's breathalyzer test registered a 0% BAC. Brown was ultimately found not guilty because the court found his 0% BAC more important than his so-called failed field sobriety test. These are just a couple of many possible defenses. The main takeaway is that as the defense, our job is to plant the seeds of doubt about the state's case, and there are many ways to do that. Plea bargaining. Another important thing to understand about beating a DWI charge is that winning doesn't always mean being found not guilty at trial. Even though this may be the ideal situation, it isn't always the best strategy. It depends on how strong the state's case is. Most criminal cases are resolved before trial by what's known as a plea bargain. A plea bargain is when someone accused of a crime agrees to plead guilty to a less severe offense in exchange for a lighter sentence. When the state has a strong case, it's sometimes better to plead guilty and take a lighter sentence than it is to risk more severe penalties at trial. Here at Rosenblum Law, we have decades of experience successfully defending our DWI clients. We're with our clients every step of the way and work hard to make sure that they feel comfortable and included throughout the process. If you or a loved one has been charged with a DWI offense, contact Rosenblum Law for a free, no-obligation consultation today.